counsel tells you that if the prosecution can't prove exactly what happened in that living room, you're required to find the defendant not guilty, check the law. It's totally 100% false, and for good reason, because the victim's dead. The victim is dead. So in murder cases, you never have the victim. But we have the evidence, and we know exactly what happened in the living room. The defendant killed Dylan Redwine. That is what happened in that living room. The defendant is guilty of killing Dylan Redwine in that living room. Defense counsel held up for you exhibit number 1, a fishing pole. It's a fishing board. It's not the fishing pole. It's in the spot where the pole would have been and should have been and was until the defendant removed it to make his story about Dylan going fishing sound good. And boy, oh boy, he would love for it to be in the book right now. But that's no fishing pole hanging from the hook, ladies and gentlemen. Because when law enforcement showed up to search, and FBI agent Rusin went under the ATV and searched the whole garage along with the rest of law enforcement, the defendant had taken the fishing pole. So look at that picture yourself. It's not a pole, it's a lure. Defense counsel started talking about the debit card and highlighted the debit card ended up being deactivated because Dylan tried to get into the account a bunch of times without having the right PIN number the defendant hadn't given to. And you're left wondering, why did the defendant have the debit card? Dylan had it on November 18th. How does it end up with this guy? And it's because he took it off of his son after his son was dead, along with the rest of his belongings. And you're left wondering, well, the card might be deactivated, but why did he empty his son's account before the remains had been found? Because he knew his son was dead and would never be able to spend a single cent, including the 6 cents left behind when the defendant took out the $2,000 on January 28th, 2013, before the remains were found. He is guilty of murder, ladies and gentlemen. Defense counsel wants you to believe that this was a rushed and biased investigation. The murder happened in 2012. The investigation was a painstaking, hard-worked, outstanding investigation that went on for years. And the La Plata County Sheriff's Office had the dedication, the commitment, and the humility to bring in the FBI, CBI, to talk to experts all around the state of Colorado, including Dr. France and Dr. Kurtzman, to do their very best, starting with, how do we find Dylan? Because although he made no effort, and he made no calls, and he made no text, there was a lot of people who wanted to find Dylan Redwine, including the La Plata County Sheriff's Office. Charges were filed in 2017. This is no rush to judgment, ladies and gentlemen. This is putting together a circumstantial case against the man that killed Dylan Redwine. It was an extremely thoughtful and dedicated investigation. When they talk about the investigation in their closing, I ask that you remember, it comes down to this. The man who did everything to cover his tracks, the man who put his son out in the woods to be eaten by scavengers, now wants to benefit from the destruction of evidence that he left behind. He wants to benefit from leaving his son in the woods to be eaten by animals. And then to stand up in front of you and say, you don't have enough now because I left my son there to be eaten by scavengers. And he wants to benefit from that? He doesn't get that benefit. Not when there's enough evidence to convict, ladies and gentlemen. So he can stand up all day long and say there's not a lot left. But there's enough left to know exactly what he did. What happened in the living room? The defendant murdered a 13-year-old boy. He murdered a 13-year-old boy and did everything he could to dispose of his remains. The experts upon whom you can rely in this case, Dr. Kurtzman, who found it to be a homicide, along with Jan Smith, the coroner, who agreed with Dr. Kurtzman, Dr. France, who one point I highlight from the defense closing, she testified, and you've been taking notes and paying such incredibly close attention, so you remember this. But she testified that if the skull had been fractured close in time to when it was found, that fracture would have been a completely different color. She believed it was blunt force trauma, and that the cuts were inflicted as sharp force injuries by another person. One of the amazing things about these experts, and why the idea that Dr. France destroyed evidence is completely contradicted by the evidence, her testimony, and common sense, is that they come in here and they don't take a position of 100% certainty. It's not how scientists operate. They say it's more likely, very unlikely. That's the world they operate in. That's the reason you should trust them. That's why when they say to you, it's very likely that it's blunt force trauma that hit him here, and Dr. Kurtzman says it could have caused his death, and I determined, Dr. Kurtzman, it's a homicide. Dr. France, counsel wants you to believe she destroyed evidence intentionally. You know from the defense expert, Eric Smith, the two-mark analyst, that casting the skull for two-mark analysis is a normal process. It's what Dr. France should have done. She is an expert. You heard her testify. She's an amazing woman, quite frankly, and a great, great forensic anthropologist, and well-respected throughout the state of Colorado, which is why Dr. Anderson admitted you want to have someone from the region look at the evidence. And when Dr. France looked at it and she did the molding, she then disclosed to the sheriff's office, the prosecution, the defense, hey, the molding didn't work. This is not someone who's destroying evidence. This is someone who's reporting out, honestly and candidly, the molding on this one didn't work, but here are my findings. Same with Dr. Kurtzman. Eric Smith, the two-mark analyst from the FBI that the La Plata County Sheriff's Office asked for assistance, says slicing cutting action was either a tool mark or something from the wild. You should ask a forensic anthropologist. And you have, ladies and gentlemen. And you've heard loud and clear, these injuries were not caused by an animal. These injuries were inflicted by this man. Defense counsel stressed in his closing that the defendant only had 14 hours to kill Dylan Redwine. That's a heck of a long time, ladies and gentlemen. And he actually had much longer, because he had 10 days before anybody started to really look at him as a suspect and before any tracker was put on his truck. And then he had months later into 2013. He's even seen by Mike Hall coming down Middle Mountain Road in April. What is he doing up there? So counsel's right, he only had 14 hours, but he also had a lot more time than that. Counsel continues in his closing argument to say it's Mother Nature. And if Mother Nature was sitting here on trial, she would say, have you looked at that guy? Because all the evidence points to him. It is not a creature from the wild. And we know that from Heather Johnson, Drayton Harrison, the animal experts. Also, the defense expert, Jerry Apker, he agrees with them. It's very unlikely an animal would ever attack someone. You heard the statistics from them. If you're out on our trails, you're probably feeling even more confident than ever after hearing how few people this actually happened to over the last 120 years. And Jerry Apker, the defense witness, said it's very unlikely that a coyote would go all the way around up to Rudman Park. It would not happen. That's the defense witness telling you that, because he's being honest with you. The bears, they're hibernating by this time, and their digestive system slows down in mid-October. So even if they're awake, they're not eating, let alone attacking someone Dylan's size. And they don't go up Middle Mountain Road as much as they're looking for places people live. Garbage cans, scraps they can find, places where there are people, which is the exact place the defendant is not looking to dump Dylan's body on November 18th, 2012, into the early morning, about hours from November 19th, 2012. And here's the thing. When we talk about animals, before you start talking about animals in jury deliberations, ask yourselves, but wait, what was Dylan doing up there? Because for all the talk in the defense closing about animals, none of which is supported by the wildlife experts, none of it. But for all the talk about the wildlife, what was Dylan doing up there? He's a boy who's thrilled to see his friends. There's no reason to go the opposite direction up Middle Mountain Road. It is away from civilization. It's away from his friends. It's from everybody he actually wants to be with in the Vallecito Bayfield area. So before you start talking about animals, remind yourself that no animal went into the living room, left Nickelodeon on the TV, snatched Dylan off the couch, dragged him out of the house, and dragged him up to the first remains site. The animal theory is even to be considered. What was Dylan doing up there? He doesn't hike. He would have called and been texting and all the things we've talked about. He's only up there because that's where the defendant dumped him. And if there's some bear that took Dylan, the bear is smarter than the average bear. He's walking around with Dylan's backpack on, using his cell phone and carrying his stuff. That is not reasonable. That is not supported by the evidence. That is not reality. That is what they want you to buy, because that's the best thing they got to sell you. But it's not true, and it's not reality, and it's not reasonable. They talk about the scavengers. Dylan's body was fed on by scavengers. The evidence shows us that. We all know that. But they didn't inflict the injuries, peri-mortem, that killed Dylan. The skull fracture from blunt force trauma, and the cuts from a sharp force instrument. Counsel talked about Dr. Anderson. The one thing I would really highlight about Dr. Anderson, who's got a lot of knowledge and experience for Southern Arizona, but he's right. You should rely on a local forensic anthropologist in making these decisions. The one part of Dr. Anderson's testimony where it's probably memorable to you because he just sort of fell apart and told the judge he wasn't going to answer questions and it wasn't relevant, was when I showed him the sock. He was sitting up there, and he's like, oh, coyotes eat tennis shoes all the time, da, da, da. I said, but take a look at the sock. And he realized he didn't have all the facts that you do. And he was sitting on the wrong side of justice in this case. Because a coyote doesn't take off a kid's sock. Toes from both feet were eaten. We know that from the forensic anthropologist. Toes from both feet were eaten. And there's an exhibit in evidence that shows the different skeletal parts of Dylan that were recovered. There's toes from the right foot, toes from the left foot, and the scat that was found there. This sock doesn't have a single mark on it from an animal. That's more consistent with someone who's dumping Dylan's clothing over the side of the trail. His shoe is chewed through, it's leather. Canids go after leather. But what's with the sock? What's with the sock is it was dumped there, and Dylan wasn't wearing it. And that's why Dr. Anderson started to struggle on the witness stand. In addition to forgetting that there was a 4-year study at his lab that showed the skull was recovered 88% of the time. That was a 4-year study at his lab. Proof beyond a reasonable doubt. So counsel in his closing on behalf of the defendant says there's a banana sticker there. And this is a great example for you to think about as you talk about what's reasonable or not. Banana sticker is either the result of an old banana peel being picked up at the crime scene as they're picking up everything and putting it in the bag, and when they're going through the stuff later, including tiny little articles of Dylan's clothing, the banana sticker from the banana peel gets stuck on the shirt. That's one possibility. The other possibility is there's some killer out there who killed Dylan. Somehow they met up on Middle Mountain Road. He killed Dylan, took careful steps to cover his tracks, then stopped, ate a banana, and tossed it down, and took the sticker and put it on Dylan's shirt. You will evaluate what's reasonable, ladies and gentlemen. There were banana peels recovered from the scene, along with the tiny little fabrics of Dylan's shirt that when you put it back together, it's the black T-shirt, the Chicago White Sox T-shirt that you saw in the picture with Dylan and his grandmother. Karen Alexander, the defendant's former girlfriend, who came in and testified earlier this week. She testified that everything she was going to describe to you happened in 2012, the Labor Day before Dylan went missing. And coincidentally, they were playing football, roughhousing, he was watching Nickelodeon. He also happened to bleed profusely and bleed right in the area where she thought, mistakenly, that blood had been identified by CBI while sitting on the couch. Except she had the wrong spot. And most importantly, as much as she tried to convince you that this was true and that all these exact facts she was providing were from 2012, the extensive investigation provided by the sheriff's office completely disproved it and showed her to be a complete someone who doesn't tell the truth. It was 2011. It was more than a year and 3 months earlier. And the other facts that she tries to give you are all fake, ladies and gentlemen. Ask yourself, that's not about her being a bad person. How did she end up on the witness stand for this guy trying to tell you this story? It's because he's guilty. She comes in and adopts the best possible version of events for the defense and says it happened in 2012 and then goes down in flames because it was actually 2011. But that's not because she's a bad person necessarily. That's not because she just wanted to show up in court and lie under oath. It's in part because she's doing it for a guy who knows he's 100% guilty of knowingly killing Dylan. No coincidence when the girlfriend shows up and tells you a story that you realize is completely false. These convenient facts she offers, which were disproven entirely, are because he knows he's guilty. And in some ways, she makes your guilty verdict easier because you know, you're smart people, you know when you're being played. The defense attorney referenced the group outside the defendant's home, whether it's a protest gathering. Quite frankly, I suggest the word doesn't matter. They're outside the defendant's home in February. Call it a protest. They're out there in February protesting. The defense put in the photograph. Look at the signs they're holding. And ask yourself, what are they demanding of the defendant? The answer is answers. They're saying, where is Dylan? Speak up. Where is Dylan? We know that you know where Dylan is. We, your children, we, your ex-wives, we, law enforcement, we, the experts, we, the jury, know what you did. Tell us. But what's really telling about this, actually, is that the defendant takes a picture of them. This is 2013. And he keeps the picture all these years. He keeps the picture all these years. Even though he's taken no action to call Dylan, text Dylan, sign Dylan, he keeps that picture. He throws these pictures in the trash.
Again, the jury will need to use its collective memory to remember what the facts are and make your decision based upon that and the law that I've provided. Go ahead.
Thank you, Your Honor. He throws that set of pictures in the trash. He throws that set of pictures in the trash. Ask yourself as a parent, when does a parent throw out pictures of their kid? Then add a word. When does a parent throw out pictures of their dead kid? It's when you killed him and you know what you did and you don't want to be reminded of it every single day. Otherwise, you do what anyone else in the world would do. You cherish these. These are the things you keep forever. If you know anybody who has kids, you know that you keep these pictures. If you can imagine someone having a kid who's dead, these pictures you never let go. He throws them in the garbage, but he can't wait to show you the protest picture and to point out the people in the picture and to again blame them when we're here because he killed Dylan Redwine. It's been a long 9 years. And it's been a long 5 weeks for you. And I just want to stop for a second and tell you how much we appreciate all your time, your attention, your diligence in doing your duty for this case. And in just a few minutes, you're going to have the case, and you're going to be able to deliberate and talk about it. And the trial's gone on for weeks, but this actually started in November of 2012. every step of the way, the defendant has done everything he can to avoid the moment that's coming, to avoid responsibility, to avoid accountability. We're here today because how many people responded when Dylan's mother called her house? Because how many people responded and did their duty when they realized there was a child who was missing? And in the first few months, that's what this was. This wasn't a criminal investigation. This was volunteer, search and rescue, family, not the father, searching, looking, trying to find a missing child. Picture that time, that effort, people doing their very best, doing their duty to find Dylan, and then once they realized he had been killed, to investigate, prosecute his killer. And in a few minutes, I'm going to be asking you to do your duty as a jury of his peers and to hold him responsible and accountable. Counsel asks you, why is this courthouse here? This courthouse is here because this is where we come to do justice. This is where we come to do the right thing. This is where we come when people harm others, which happens, even in a beautiful community like this. It happens. No community is immune. And murders almost always happen behind closed doors. And we look to the evidence to hold the killer accountable. And there's a mountain of evidence standing behind us here. And it all points to this man being the killer. So we come to this courthouse for justice to be done. And we ask you to do that, ladies and gentlemen, by relying on your common sense and your life experience. It's been a long 5 weeks for you. You've heard a lot of evidence. I'm not going to get into the DNA evidence, and I imagine you're breathing a sigh of relief in your own mind when I say that. The only thing I'm going to say about DNA is counsel wants you to think a lot, talk a lot, ponder a lot about the weight of the DNA swabs. I would just ask you to rely on the expert called by the defense on DNA, who went and asked Ms. Kramer, is there enough weight there to develop a DNA profile? Yes. Can you determine by the percentages who the contributor of blood is? No. But you can do DNA profiles off that weight? Yes. That's the defense expert. So while I recognize we spent a lot of time talking about weight in the defense closing, rely on the defense expert. But there was certainly enough weight there. You have the experts, but you also have your own common sense and life experience. Knowingly killed Dylan Redwine. Knowingly. Knowingly is flying to a violent rage and hitting someone in the head hard enough that you kill them. We've all hit our heads. We've also seen kids hit their heads, and we have that moment of terror when we think something's actually happened. And then 5 minutes later, everybody's okay. Like Dr. Kurtzman talked about, the force that's required to actually kill someone by hitting them in the head. That's what he did to Dylan Redwine. And all the evidence points to that. Knowingly is trying to get rid of his body. Knowingly is cleaning up the blood. Knowingly is putting a knife into bone. No one says it happened in the living room. But we know it happened. He put a knife hard enough into his son that he was able to cut bone. Look to the experts. Follow the experts. But follow your common sense that knowingly is hiding a body. Knowingly is dumping a body. At its core, this is a simple and tragic case. You're almost done. You're going to reach the right verdict in this case. And you're going to find the defendant guilty. And then you'll be able to go back to your regular lives. And let's assume for a moment tomorrow night, you're able to go out and relax. And you could finally talk to your loved one about what you were doing here for the last 5 weeks and what you heard and why you found the defendant guilty. And this is what you would say. Mark Redwine was the last person seen with Dylan. Mark Redwine was the last person with Dylan when he was heard from by anybody in the universe. He had the opportunity and the reason to hurt Dylan. Whether it's the poop pictures, whether it's a fight they're having, an argument, he took his head, Dylan's head, with enough force to kill him and made cuts into his bone. killed Dylan. You'll tell your loved one. He's also guilty because he had Dylan's blood in his house. And there was DNA found there. And he had the smell of a human body, a human remains dog, alerted on multiple spots in the same room where they were sitting, that same room that I just talked about where there was blood found, where there was tension and anger, and they were roughhousing. And the smell of human remains in his truck. Counsel showed you that picture of the fingernail. You can go back and check your notes. That fingernail is actually found in the front driver's seat area. The dog hid on the back seat. So as much as we'd like to believe that human remain dogs are alerting on fingernails, which I would submit to you doesn't happen, that fingernail is not even in the right place for that argument. That's in the front driver's seat, the driver's fingernail, presumably. The dog's alerting to the back and to the cab of the trunk. And when you're telling your friend about why you reached the verdict you did in this case and held this guy responsible, you'll be able to tell him or her how incredibly evasive he was and misleading and suspicious, all of which is consistent with killing Dylan. You'll talk about how close the remains were found to the defendant's home. Not just in one location that Dylan had no other reason in the world to be in, but in two separate locations. And what that means in terms of the defendant trying to get rid of Dylan's head because it shows injury. And that the defendant was the only person who had any reason to take Dylan's belongings after he killed him. The only person. And he ends up with one on him, the bank card. He took Dylan's stuff. And he has one of those items. And you'll talk about the remains showing injury to Dylan that resulted in his death. On November 18th, 2012, Elaine Hall experienced a parent's worst nightmare. The worst nightmare a parent can have. When you send a text at 10:09, as Elaine did on the night of November 18th, "How's it going, son? You okay?" She's been waiting 9 years for a response. She's been waiting 9 years for a response because this guy killed her son. And this is the response she gets now. No, your son was not okay. Mark Redwine killed him and should be held fully responsible and fully accountable, ladies and gentlemen. He is guilty of second-degree murder and child abuse resulting in death. Thank you.
All right, instruction number 26. The bailiff will now escort you to the jury room, where you will select one of your members to be foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on, according to the rules that I'm about to explain. The verdict for each charge must represent the considered judgment of each juror. It must be unanimous. In other words, you must agree to all parts of it. This also applies to any determination that you make in response to verdict questions which you conclude should be answered. Only one verdict shall be returned, signed for each count. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching the verdict, and if required by a verdict, answering any verdict questions, you will inform the bailiff, who will in turn notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 2 verdict forms. When you have unanimously agreed upon your verdict, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. Similarly, if you conclude that the verdict question should be answered, you will select the option on each verdict question which reflects your unanimous decision, and your foreperson will sign each verdict question form as I have stated. I will now read you the verdict forms. You must not draw any inference based upon the order in which I read them. The verdict forms which you will receive read as follows. Jury verdict, count number 1, murder in the second degree. 1, we, the jury, find the defendant, Mark Redwine, not guilty of count number 1, murder in the second degree, and the lesser included offense of criminally negligent homicide, a place for the foreperson to sign. 2, a place to make a mark, and then we, the jury, find the defendant, Mark Redwine, guilty of count 1, murder in the second degree, a place for the foreperson to sign. Below that is another place to make a mark, and we, the jury, find the defendant, Mark Redwine, guilty, count number 1, of the lesser included offense to count number 1 of criminally negligent homicide. The foreperson should sign only one of the above. If the verdict is not guilty as the offense charged and the lesser included offense, then one above should be signed. If the verdict is guilty as to the offense charged or a lesser offense, then the offense listed in 2 above, which the jury has unanimously agreed as to the guilt of the defendant, should be marked with an X and signed by the foreperson. While the jury may find the defendant not guilty of both the offense charged and the lesser included offense, the jury may not find the defendant guilty of both the charged offense and the lesser included offense. Jury verdict count 2, child abuse. 1, we, the jury, find the defendant, Mark Redwine, not guilty of count number 2, child abuse, and the lesser included offense of child abuse committed with criminal negligence, a place for the foreperson to sign. Number 2, we, the jury, find the defendant, Mark Redwine, guilty of count number 2, child abuse, and a place for the foreperson to sign. Below that is we, the jury, find the defendant, Mark Redwine, guilty of count 2, child abuse committed with criminal negligence, a place for the foreperson to sign. We, the jury, find, with respect to the verdict question for this count, as follows. 1, did the child abuse result in death? Answer yes or no. A place to mark yes and a place to mark no, and a place for the foreperson to sign. The foreperson should sign only one of the above. If the verdict is not guilty as to the offense charged and the lesser included offense, then one above should be signed. If the verdict is guilty as to the charged offense or the lesser included offense, then the offense listed in 2 above should be signed. 2 above, which the jury has unanimously agreed as to the guilt of the defendant, should be marked with an X, signed by the foreman, and the jury should answer the verdict question. If the verdict question is answered, the foreman shall sign the verdict question. While the jury may find the defendant not guilty of both the offense charged and the lesser included offense, the jury may not find the defendant guilty of both the charged offense and the lesser included offense. So, now is the time that you'll get to go back and deliberate. I need to know if everybody's feeling okay. And is there anybody who does not feel like they can deliberate on this case? Looks like everybody's feeling well. We have 2 alternates remaining in this case, and they are Mr. Grotfend and Ms. Rios. So I'd like the 2 of you to stay briefly, and then we'll let you go downstairs and pick up your stuff if you need to. I need to give you an instruction and tell you what's going on from your end of it. Everyone else will go down and deliberate. You can decide how long you want to stay tonight. If you want to leave at 5 like you've been doing, that's fine. Come back tomorrow. You can set the time tomorrow that you want to come back. If you want to stay late tonight, you can do that too. If you do stay over the lunch or dinner hours, we will provide you with a meal. So Cindy, I need for you to come up so I can swear you in, please. Raise your right hand. Do you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, that you will not permit any person to speak to them or speak to them yourself, unless by order of the court, except to ask them if they've agreed upon a verdict, and that when they've agreed, you'll return with them into the court? Thank you. We will, there's a lot of stuff up here that you have to have downstairs in the jury room. We will bring that down to you along with the original verdict forms. But with that, everybody rise for the jury. And everyone but Mr. Grotfend and Ms. Rios can go downstairs. Okay, we can be seated.